Welcome to my online learning session. I am Dr. John, and in this short video lesson, we are going to cover the first unit in business laws, that is Indian Contract Act 1872. The existence of law is very much essential for maintenance of peace and order in the society. Indian laws are mainly based on English laws and other foreign laws from where it derives its inputs. The characteristics or features of agreements such as plurality, consensus ad idem, promise or reciprocal promises, and enforceability by law are important for a valid contract. Indian Contract Act 1872 helps us understand the definitions of contract, promise, agreement, valid contract, and the related terms. We also learn about the essential components or elements of a contract, what mercantile law is all about, and why business laws are required. Laws are required to maintain peace and order in our society. Laws lay down guidelines or the do's and don'ts regulating public behavior for a harmonious coexistence in society. Also, laws provide remedies against a person who fails to perform the elements of the contract. The branch of law that deals with trade and commerce is called mercantile law. So what is its scope? Scope means what all would come under it. It includes contracts, sale of goods, Negotiable Instruments Act, the Companies Act, insolvency, insurance, carriage of goods, etc. Let's now take a look at sources of mercantile law. Indian mercantile law has been put together by taking inputs from the English mercantile laws, Indian statute law, judicial decisions, as well as customs and usages. Let's go one by one. The English mercantile law derives its inputs from the common law of England, equity, where justice developed by judges take precedence in concluding or passing orders in certain cases. Then the English statute law enacted by the British Parliament, and the law merchant or lex mercatoria, which is based on customs and usages prevalent among the merchants and traders over a period of time across the English land. Next is the Indian statute law. These acts are passed by the Parliament of India or any state legislatures across the country. For example, the Indian Contract Act, the Sale of Goods Act, the Indian Partnership Act, the Companies Act, etc. came forth or came into being because it was either passed in the Parliament or in a state legislature. Next is the judicial decision. A court's decision in a particular case takes precedence for what comes after that, or the successive cases. So this is done mostly in cases where it becomes difficult to reach a conclusion or where there is no law passed earlier, but the court, the lawyers, and the judges would rely on previous judicial decisions made in the same or related cases. And finally, customs and usages. Certain practices in business communities are also an important source of the mercantile law. Courts also take that into account, giving it a status of recognition. Time to define the term contract. It is an agreement enforceable by law. Here there are two aspects: agreement and an agreement enforceable by law. Let's take an example. I agree to buy Mr. John's car for rupees 2 lakhs. John in turn agrees to exchange his car for the price of 2 lakhs. This transaction becomes valid in the eyes of law only when both parties sign a sale deed as per the stamp duty prevalent in the country or state, using the text which captures all elements applicable to a valid contract. In addition, documents from the Regional Transport Office, which is the RTO, should be filled up to effect transfer of ownership, and also contact the insurance company to reassign the policy which is right now in the owner's name, that is in John's name, to my name. What is promise versus agreement? I could verbally give a confirmation to Mr. John stating my interest in his car, assuring him that I'm going to buy it, which is not an agreement but just a promise. When I make an offer of 2 lakhs and when Mr. John agrees to my proposal, accepts my proposal, it becomes an agreement. Therefore, if I were to use a short formula, offer plus acceptance is equal to agreement. Let's take a look at the characteristics or features of agreement. Number 1 is plurality, where 2 or more than 2 persons are involved. Number 2 is a Latin term, consensus ad idem, or you can pronounce it as idem, which means agreeing on the subject matter by both parties. So there is a consensus or general agreement reached. Third is promise or reciprocal promise. I give a promise to get a reward as a reciprocal promise. I tell a person that, no, I promise to pay you 2 lakhs, and the other person says that, okay, in response to my promise of 2 lakhs, he promises to give me the car or bike or whatever in return. So all promises do not necessarily reach an agreement or later a contract, but all contracts are necessarily agreements. The characteristics of agreements are what we just saw, and now let's move on to understanding the factors or features that make a contract valid, the elements that validate a contract. Number 1, offer and acceptance. The offer and acceptance must be consensus ad idem, which means both parties must agree on the same thing in the same sense. Next is intention to create legal relationship. Intention of both the parties to a contract must be to create a legal relationship. Number 3, capacity to contract. Parties consenting to the contract should be of sound mind, should have attained the age of maturity, should be solvent, which means they should not be bankrupt at the time of entering into agreement. They should not be under the influence of drugs or alcohol, which means they should not be in an inebriated condition. Next is genuine and free consent. A valid contract must be freely obtained without any force or coercion. Consent is said to be not free when it is obtained by coercion, undue influence, fraud, etc. Next is a lawful object. The object of the agreement must not be illegal, immoral, or against public policy. We move on to the next one, which is a lawful consideration. Consideration in most cases would mean payment, but it also involves a case where you exchange for something for kindness, not just cash. Consideration becomes essential to a valid contract, and the elements of a valid contract states that an agreement between parties must be backed by consideration, which means both parties should give and get something in return. So I give rupees 2 lakh to John, and John would give his car in return to me. So there is exchange happening there. It can either be in cash or in kind. So you cannot mandate it to be only in cash. It can also be in kind. The next one is certainty and possibility of performance. The terms of the condition should be certain and not vague. It should not be ambiguous. An agreement to do an impossible act cannot be enforced at all. And finally, legal formalities. A contract should be enforceable in a court of law, which means it should be valid. For it to be valid, it should have all elements that would validate a contract. It must comply with the necessary legal formalities, which are administrative in nature, as to the way of writing or drafting the text, stamp duty, registration, certification, and witnesses to the contract. And finally, let's compare agreement and contract. Let's take a look at the table. Number 1, agreement is offer plus acceptance, whereas contract is agreement plus its legal enforceability. Number 2, an agreement may create social or legal obligations, whereas a contract creates only legal obligations between the parties. Number 3, all agreements do not become contracts. All contracts, however, are based on agreements. That's all in this video on Unit 1. We will cover classification of contracts in Unit 2. Here is the video already ready for you. If you have any questions pertaining to Unit 1, please feel free to make use of the comment section below. Happy learning. Bye for now.